Hello, everyone, and welcome to the Exchange Chambers podcast. This is one of a series. We are speaking on the 13th of June, 2024. Thank you for listening. Feel free, please, to give feedback on this to either of us. We are going to talk today about death and maternity care, but let me first introduce myself. My name is Louis Brown, King's Counsel.
I'm Sarah Sutherland.
And we are both barristers in Exchange Chambers, Manchester, Liverpool and Leeds. So we're going to talk about death and maternity care, and we're going to consider, in relation to a particular case, what can go wrong and what might have been done differently so as to change the outcome in this tragic case. We're going to be talking about a baby called baby Ida, and this is a real case, as you might anticipate, and it's coming to a final inquest in February of next year, which Sarah and I will appear on behalf of baby Ida's family. So I'm going to begin by asking Sarah, can you just talk through the facts, please, of this case?
Yes, it is a tragic case. 37-year-old mum, no problems during the course of the pregnancy. She is admitted to hospital, and then thereafter the baby's born in a very poor condition. Ida is resuscitated, she's cooled, and then she's transferred to another hospital, to a specialist unit. But she died 6 days later. One of the interesting parts to every maternity case is quite often if there was transparency, if there was openness and help given to parents to understand what has happened, then there wouldn't be such a significant repercussion for the family. They wouldn't be so damaged by the events that they've gone through. Of course, they've lost a baby. In the parents' case, Ida's case, the hospital shut the doors and really shut them out of any explanation as to how their baby had come to die. And so that's where we became involved. We were asked to read through the medical records and to see if there was anything that we could help with. Now, pausing there again, reading through medical records, I don't know about your experience, Lou, but the family had the records. They'd been given the records, but they'd been given the records on the labour ward on their own to navigate. Well, for us as lawyers well versed in clinical negligence cases, it's quite often very difficult to navigate. But for a bereaved family, hearing other mums give birth, to just be handed your notes is really quite hard.
Yeah. So baby Ida died of hypoxic ischemic encephalopathy, which we'll shorten to HIE. That's right, I think.
Yeah.
Just before we turn back to the facts of Ida's case, and there's a general school of thought, which is that if a baby is alive and well at 37 weeks, then after birth, that baby should go home happy and healthy. Otherwise, something has gone wrong.
Yeah.
And that's certainly a school of thought that we subscribe to as professionals in this area. And it's also, I think, the case, Sarah, that most avoidable deaths are due to HIE.
Yes. And it doesn't necessarily, we're not saying that every case there has been an aspect of negligence. That's not what we're saying at all. Things do go wrong, but it is that transparency that seems in the cases that we're involved in, and certainly that I've spoken to bereaved parents, that the transparency is missing. And so in Ida's case, the medical records did suggest that something had gone wrong. Now, there is a bit of a backstory here, because the hospital in question had done an RCA or an SIR, or it's known in various terms, so serious incident report, serious incident review, root cause analysis, all sorts of different names given to an internal investigation. What went wrong? Why did that baby die? And we'll come to what they said in their conclusions. But the RCAs, the internal investigation, was only received after the parents chased and pushed to get an answer. What had happened? How had she died? When the RCA was received by the family, their findings and conclusions were effectively, our communication was good, our documentation was good. We could have done a little bit more, but actually this was one of those outcomes that clinicians felt they didn't need to do anything differently, which was really quite surprising, because behind all of that, the HSIB had prepared a report, and there had also been something called a PMRT, that is a standardised perinatal mortality review tool, which is something I think that is UK-wide, that is invested in by trusts, by health boards. And so the HSIB is a separate standalone organisation, but the other hospital that baby Ida had been transferred to had done a PMRT. Both of those documents, those investigations, had heavily criticised a number of actions and steps that had been taken during the course of labour and after birth. And I think that's, for us as lawyers, somewhere that we need to start. The HSIB, where they're involved now, they have actually been incorporated within another government organisation. If you look for HSIB, you'll find that they are now part of the CQC. And the PMRT is something that all hospitals should be investing in. This is a standardised perinatal mortality review, England, Scotland and Wales, and that's an investigation that reviews and that you would hope hospitals learn and improve and evolve. So that's what had taken place elsewhere, but at the hospital in question, their RCA was very different.
And in fact, it found, I think I'm right in saying, Sarah, that there were no lapses in care that contributed to or were the root causes of the very sad outcome.
Despite
the other findings. So if we then just talk about the issues that with the care that were identified as relevant to the outcome, and considering issues relating to intrapartum care, it's clearly very important that labour is assessed, and where there are changes, those changes are considered carefully and managed appropriately. What was the situation in baby Ida's case in that regard?
So the PMRT specifically identified a lot of things that had gone wrong. So, for example, the CTG hadn't been read correctly. The labour room, the birthing room that the family were in was very small. The chair was positioned so when the mother tried to get out of the birthing pool, she couldn't actually get on it. There was no emergency feel to what was going on, so the family didn't understand how important it was, and it went on. The PMRT identified all of these issues related to intrapartum care and fed it back to the hospital. So there was this communication, this identification by another hospital saying, look, these are the things we think you could have got better, or you should have done better, and the hospital failed to act on them.
So clearly that's important. If you have another hospital which isn't invested in the case in the same way as the relevant hospital where baby Ida was born was concerned, then you would have thought that would be something that should be paid close attention to.
Absolutely.
Because it's independent in that sense, and it's contributed to by relevant experts.
Yeah.
And that should encourage a culture of openness.
Exactly.
And willingness to acknowledge that things have gone wrong.
Exactly.
And that had things been done differently, the outcome, if this is the appropriate finding, might have been changed. Mm-hmm. And of course, the reason why that should be done is not only because it's part and parcel of a duty of candour, whether a statutory duty of candour or otherwise, but it's critically important for parents who are affected by the death of their baby, that there is an acknowledgement.
Yeah, and that it's not going to happen again. And this is the point that we come back to time and time again with tragic cases involving the loss of a baby. Any other environment, you expect evolution, you expect learning, disseminate the learning. What has gone wrong and how do we improve? How do we avoid that happening again? Whereas that's just not what happens here. Now, it may be this is an isolated trust, and trusts elsewhere behave very differently, and I really hope they do, because another hospital using their expertise to help understand what has gone wrong. I don't understand why you wouldn't embrace it and say thank you, but also then communicate that to the family, because the family want to know what's changed. How do you avoid that happening again? And quite often, I think, if there was openness with families and explanations as to what's gone wrong, the families would stop there and say, well, thank you. Thank you for acknowledging something's gone wrong. We are relieved things are going to change. And that would be it.
Yes.
There would be no claim that follows. But it's this, doors are down, shut, you're not getting any communication, that leads to despair, frustration, and this, well, we've got to get answers, we've got to push.
Yes. Yeah, a culture of defensiveness is, which we do sometimes see. It's far from universal. I'm not suggesting that for a moment, but a culture of defensiveness, when there are legitimate questions being raised and answers properly sought, is one that will engender a sense of distrust.
Yeah.
And from that, the cause polarization of the positions,
Yeah.
rather than working together, parents and trust, to commit to an outcome and learning from it. And that leads to litigation.
Exactly.
It leads to expense, not a satisfactory outcome.
And why wouldn't you look at what other people are recommending? You know, we would do that.
Yes.
If another barrister were to say, well, I think you could have done this, or did you think about this, or what? And we always bounce ideas off each other.
Yes.
Why wouldn't you? And now I understand that everybody works within tight resources and time and money and so on and so forth. But in Ida's case, the fact that there were other organisations saying you could have done more, look at this, investigate this, and the trust did not.
Yeah. And some of the criticisms that were made by the independent investigation were inappropriate use of a particular type of fetal monitoring in established labour. The fetal heart rate monitored in established labour was not carried out correctly. The interpretation of the fetal heart rate monitoring was not correct. The technical quality of the CTG was poor. And then moving on to the resuscitation, the initial resuscitation was not carried out appropriately. During that resuscitation, the baby's temperature is not maintained within an appropriate range. Baby was cold on arrival in the neonatal unit. So these are really very, very serious failures, and not an isolated failure, very significant failures in relation to this birth. And the HSIB, I think, went even further in their findings.
Yeah, they did. I mean, the factual matrix for this is CTG wasn't read correctly, and time was wasted trying to attach a fetal scalp electrode through an FSE, and that was tried by one midwife, and when she couldn't do it, then another midwife tried. So all of this time was being wasted. And then when baby Ida was born, she was cooled before she was stabilized, and then she was tracked. So like you say, it is really basic administration of medical care that was deficient, and it should have been identified by those reviewing it. And the HSIB, what was quite sad was that the trust dismissed what the HSIB had said and questioned it. Now, the HSIB author was a midwife, but she sought the advice of a neonatologist and an obstetrics expert. And so they dismissed it completely and didn't accept what was said. The HSIB report runs to many, many pages identifying all of the issues. Now, what happened after that is the family asked to discuss the case with the lead clinicians, and so they met with the director of the obstetric care and the head of midwifery. And they, in that meeting, the family very wisely asked if they could record it. And so they recorded it, and we had it transcribed subsequent to that appointment. I should say there were no lawyers on behalf of the family in attendance, but of course there were lawyers on behalf of the trust.
Notwithstanding the position taken in the two independent reviews, it's right, I think, to just record a couple of matters that are relevant for the purposes of the inquest. One is that initially the death wasn't reported to the coroner.
No, but that was something the family pushed for as well. They couldn't understand. If nobody knew why baby Ida had died, why was the coroner not investigating?
Yeah. And during a hearing at the coroner's court, the position statement of the trust in a number of respects expressly contradicted a position taken by the independent reports and advanced a case that was expressly contrary. So, in particular, that management didn't contribute to the eventual outcome, and questioned whether, even if delivery had occurred sooner, would that have affected the outcome? They said no.
Absolutely.
So even as late as the coronial investigation and a step at court in that investigation, you have this culture of defensiveness. And in fact, further, you're advancing a position which is expressly contrary to independent expert reviews. And again, that only serves to diminish trust and confidence that the family might have in the position of the trust, even as late as the coronial investigation.
Exactly. I think there was another factor which was fed into this distrust by the family in the meeting they'd had with the clinicians, the head of midwifery and the obstetric lead. They had said, we accept that there were lapses in care. We'll redo our RCA, so our internal investigation. We absolutely understand why you feel like that. Now, we know that they said that because, of course, we've got the recording. But the family subsequent to that meeting got a letter. In fact, I don't even think they did them at the service of writing them a letter. I think it was during the course of submissions to the coroner that they said, we're not redoing the RCA. We don't think we need to. So the family, again, they make a little bit of progress, and then immediately a sledgehammer hits them again of this at the pre-inquest review. No, it wouldn't have made any difference. We didn't do anything wrong.
So just looking further forward then, and looking at the position from the perspective of both representatives of the families themselves, of course, and the trust. Our advice, I think, would be that the trust really need to, where there are problems, they need to admit the nature and extent of those problems. They need to identify and develop measures to promote effective multidisciplinary team working, particularly between paediatricians, obstetricians, midwives, neonatal staff.
Yeah.
What else, Sarah, would you think?
Sit down with the families. What are the families' concerns? What do the families hope to achieve? That communication is so important. So it seems to me that, the care, the empathy, recognise that something has happened to that family. Don't put them on the labour ward and hand them the notes. Take them somewhere quiet. Talk to them about what's happened. For me, that is a really important step. And would very much be progress for the trusts. And incident reporting, how many times do we find that these investigations are poor, really poor? And how do you evolve as an organisation? How do you improve? How do you learn? How do you get better without a thorough, detailed investigation by the right people?
Yeah. Well, I completely agree with all of that. So that, I think, concludes this podcast. We're happy for you to contact us in Chambers if any questions or issues arise that you would want to exchange views with us on. But once again, can we thank you very much for listening?
Thank you.